Hi, my name is Josh Blackman, and welcome to the 2022 Harlan Institute Ashbrook Virtual Supreme Court competition. We are now in the semifinal rounds, and we are arguing the case of students with fair admission versus University of North Carolina. I am honored to present our two teams today. From Minnesota, the Eden Prairie High School, we have Avik Garg and Anthony Petrescu. And from the Dublin Christian Academy in New Hampshire, we have Elijah Johnson and Aidan Gillison. Petitioners begin whenever you are ready.
Thank you, Mr. Chief Justice, and may it please the court. The 14th Amendment bans racial classification. This principle was identified in both Brown v. Board by unanimous court and Plessy v. Ferguson by Justice Harlan dissent. UNC's discrimination against Asian Americans violates this principle. And although Grutter and Bakke pointed to diversity as the compelling interest that could overcome the odiousness of racial classification, not only do we believe that this is wrong, but we believe it is egregiously wrong, as diversity is racial balancing in disguise. As such, Grutter and Bakke should be overruled, and UNC's discrimination against Asian Americans should be deemed as unconstitutional. We welcome the court's questions.
Okay. So let's start with history, Counselor. We talk about the Reconstruction Congress. Talk for a bit about what were the laws passed by the Reconstruction Congress that may bear on this case.
Sure. So some of them would be like the Freedmen's Bureau Act is probably the most famous example, and that's the one that's cited in our opponent's brief, our friends on the other side's brief. And then a couple of others were about like the surrounded things like we cite them in our brief, but I can't exactly tell you what they are now. But I think what we would say about a lot of these is that a lot of them were about helping slaves rather than helping African Americans. And we think there's a crucial difference there because helping slaves is about helping those who were treated unjustly during early American history. Helping African Americans is about doing something based on race. And so while those two happen to coincide, we think that using race as a proxy is never a good idea. And that as this
there was some legislation that specifically said we're giving benefits to people who are colored. That was a phrase he used back there. People.
I think that was basically only one act. There were a couple of acts that sort of referenced around that. The one act that I think did that was the Military Act. That was about helping, there was something about a bounty and that African Americans got a different level of bounty. I forgot exactly how this system worked, but that one actually probably would meet some level of like intermediate scrutiny, not strict scrutiny as we know it today, but it at least was somewhat different. The history is not as clear, we think, that as respondents make it out to be.
All right, well then let's talk for a bit about assuming you're right that these Civil War era statutes were about race, and were about conditions of slavery and not race. What would that actually mean for us today? Can race ever be used when the government makes a decision?
I think we need to look at it in terms of what that is inherently doing. We talk about race and whether these decisions would be made based off of that. I think we need to put them in different blocks of different sections of people. For example, if we're targeting, a group of people that we might see as predominantly poor, and we cite them as a group of, African Americans, I think that instead of that, we should look at, socioeconomic status, whether they're within a certain income range, to focus that law.
Okay, I get that you make a big deal of the socioeconomic stuff, but let me ask the question differently. Let's say that a university only uses socioeconomic status and doesn't even inquire about race. And then it turns out that the entering class is like 99% Asian and white. There's like, 12 Black kids in a campus of 1,000. And they've tried and they just cannot get more people using only socioeconomic status. What do you say to that university? What's your response?
Well, if you let me fight the hypo for like 5 seconds, we did do a simulation.
You can try. Let's see how far you go.
Yeah, we did do a simulation on socioeconomic preferences, and we did find that basically if the minorities actually increase.
It's hypothetical. So let's say that your simulation was wrong, right? Let's say that in reality, we come back in 5 years, and your simulation was wrong. We can, people are wrong, make mistakes, right? It happens. What do you say to us then? Do we reconsider, or do we stand by this decision?
Sure. If it's in that exact, if if this is wrong, then we think that what you should say is that, well, you're out of sort of luck in some sense, that diversity is not a compelling interest unless it's really, really helping with the educational benefits.
Well,
And if
you're pivoting now to make sure. So your point is basically too bad. Is that your answer to the university?
my point is that it's still racial classification, right? My point is that if you have that situation and then you sort of implement racial classifications as a way of solving that system, it's a racial classification. And so then we sort of start a strict analysis. And we think that at the first step, that diversity itself is not okay, that we have to point to something more specific. And that if you point to something more specific, like say educational benefits,
Is that a compelling interest? And you said it wasn't.
Yeah, we don't think diversity is a compelling interest. We think
Is there not? Is there not? I'm sure to make sure I understand.
It's not.
So that part of Grutter is wrong.
Yeah, Grutter is wrong.
You think anything is gained by having racial diversity in the university campus?
I think that probably there are gains, but we think that those gains should be the compelling interest, such as like educational benefits, and that we should analyze that through strict scrutiny. We should see if the racial classifications are then are narrowly tailored to promoting those benefits rather than diversity itself.
If we were to rule today that a diverse student body is a compelling interest, you still win?
Could you repeat that? Sorry.
Yes, if we were to rule today that diversity is a compelling interest, does your case lose there or you still win?
I think we still win. When we look at Bakke and Grutter, that established precedent, we see that they required race-neutral alternatives. In the case of UNC, we don't see that they require those race-neutral alternatives, and thus they haven't done their due diligence to actually seek an alternative method that wouldn't just cite racial classification to achieve those educational benefits of diversity that are labeled.
Well, let me ask you the question a little bit differently, right? We've had Bakke and Grutter now for decades, and we've come to rely on these precedents. How does stare decisis affect how we should treat these precedents, which we've run for a very long time?
Sure, I think that we should treat them like this court did in Dobbs last term, that we should look at the stare decisis factors. We think that first there's the factor of whether it's wrong and egregiously wrong. We think that that factor goes our way because we think the diversity is just not a compelling interest in any sort of traditional sense, and that it's logically inconsistent with the previous sort of ideas of structure.
But there is reliance, though, and maybe it's different than Dobbs. Universities have developed these elaborate admission systems based on the Grutter standard, which they've allowed to use for years, and you're just saying get rid of it. And isn't reliance a little bit different in this case?
Sure, Justice Blackman, but I think that the reliance is weaker for another reason, which is that Grutter itself talked about a 25-year limit, and that we think if universities were taking that seriously, that there's no reason that they should have any reliance based on Grutter. And that Justice O'Connor herself probably would have thought that universities should not be relying on that, and that we should not be sort of sticking to that decision, even if we think it's wrong.
Proceed.
Sure. And then I think the third factor would be workability. And we think that just the workability is also something that should be questioned here, because if we're talking about sort of pronouncements in Grutter, things like whether or not that race neutral alternatives are being followed, whether or not that sort of critical mass is being met, we think that those things are just not workable.
Right, let me ask you differently. Let's say we rule in your favor and we have to write an opinion, or we have to write the decision. And we say universities shall not X, they cannot do X. What do we write?
We think that you can say that universities cannot use race as a deciding factor.
Deciding factor. So they can use it in one of many factors?
No, if race is one of any factors, then it's being used to choose between two applicants. So we think.
But isn't that what Grutter said? Race can't be used as dispositive. In other words, what you just said is consistent with Grutter.
Well, I think that if Grutter meant what it was saying, then race cannot be used as one of many factors, because we think if there are two applicants and that if one applicant gets in based on their race, even if it's viewed race as one of many, many factors, if absent that race, then if they were a different race, they
Race
not.
Does the record show that race is such a deciding factor at UNC? Is there evidence about that?
Yes, because the district court below found that African Americans were given a boost based on their race, and Hispanic
Difference
Americans.
between a boost and deciding factor. So I want you just to spell that out for me, please.
Yeah, so this is what I'm trying to say, that if it's a boost, even if it's one of many factors, that is itself a deciding factor, because even if even if an applicant does not get in just because they are African American, if two applicants exist and one applicant is getting in over the other applicant, so in that specific instance, that's when we think it becomes a deciding factor, dispositive in that scenario. And I see that our time is running up, so thank you, and we pray.
Thank you so much. Thank you so much, Counselor. All right, respondents, you have 15 minutes. Begin whenever you're ready.
Thank you, Robert. Mr. Chief Justice, and may it please the court, I, Elijah Johnson, and my co-counsel, Ethan Gillison, are arguing on behalf of the respondents. The court must not overrule the case of Gruber versus Bollinger. This afternoon, we will be discussing in two sections how the framers of the 14th Amendment divulge their beliefs on the race legislative acts, and how that does not pertain to such things such as sexual orientation and gender, and how the student body diversity and the preferences needed for these for this affirmative action, and how long it will be needed.
Your Honor, we will also be discussing the 14th Amendment and why it was made. It was made to promote equality, Your Honor. I will also be discussing the 14th Amendment does prohibit race quotas, but does not prohibit race being taken into account in the admissions process. The 14th Amendment rarely hammers the idea of equality, and the definition of equality is the state of being equal, especially in status, right, and opportunities. And Your Honor, I really want to key in on that word opportunities. In Grutter, we see the quote, "We have reportedly acknowledged the overriding importance of preparing students for work and citizenship." We see these are opportunities for these minorities, describing education as a pivotal to sustaining our political and cultural heritage with a fundamental role in maintaining the fabric of society. Grutter then quotes Plyer versus Doe, where it says, "This court has long recognized that education is the very foundation of good citizenship. This is found in Brown versus Board of Education." Grutter then goes on to say, "For this reason, the diffusion of knowledge and opportunity through public institutions of higher education must be accessible to all individuals, regardless of race or ethnicity."
Okay, Counselor, if I could just jump in for a minute, please. Your friends on the other side mentioned Justice Harlan's dissent in Plessy versus Ferguson. Can you please address that opinion?
May you repeat that, Honor? I'm sorry, we're a little bit far away from that.
I know, and we're not hearing great. Maybe you can get a little closer to the camera. Is that possible?
Yeah, definitely.
Yeah. Okay, that's good. Thank you. And you're tall, but we'll understand. No, that's fine. You don't have to hunch. That's fine. My question was, your friends on the other side mentioned Justice Harlan's dissent in Plessy versus Ferguson. Can you please address that opinion?
Oh, Your Honor, could you really quickly just recap that dissent? We have a lot of information. Sorry.
Justice Harlan's dissent in Plessy. Can you please discuss it?
Yes, Your Honor.
Yeah, you really shouldn't be flipping on a tablet.
Sorry, Your Honor.
Yeah.
I didn't have any paper with me at the time. I apologize.
Yeah. So, are you familiar with the case or no?
We are not. No, not as much as we should be. Apologize.
Okay, that's fine. In Plessy versus Ferguson, Justice Harlan said the Constitution is colorblind. Do you agree with that?
Your Honor, previously when the Constitution was first written, I believe that it wasn't colorblind, since there were many parts of the Constitution that referred to maybe slaves or human property, if you will. I believe that in later decades, especially ones closer to our day and age, we've made great leaps, especially with the civil rights movement, that we have actually been able to make leaps and bounds over that color blindness, and that it's not based, the Constitution is not going to apply to everybody, and we will discuss how this equity and equality is based for all and not just one particular racial group.
Okay. Counsel, let me ask you another question. How do we deal with the fact that your universities, right, are not giving us any sort of end game, right? You say you're going to need these racial preferences today, tomorrow, forever. How do we deal with that fact?
Well, Your Honor, we see this this question being addressed in Grutter v. Bollinger, where it says, it has been 25 years since Justice Powell first approved the use of race to further an interest in student body diversity in the context of public higher education. Since that time, the
That
number
was like 22 or 23 years ago, right? That was a long time. So I mean,
Yes.
haven't we already reached that point?
Your Honor, as it was previously stated in our brief and our oral argument, Justice Kagan wrote with her dissent of Dobbs versus Jackson that that the law should always stand unless there is a, I'm paraphrasing, but I apologize, but the law should always stand unless there is a dutiful and justified need to actually change it. And that is to say that we must stick with the decisions made by previous Supreme Courts. Otherwise, there will be chaos and constant confusion within
But if Grutter itself put a 25-year clock, isn't everyone on notice that this can't be used forever?
Your Honor, we do agree with that statement. This idea of race-conscious admission should be used until it is not needed. When we see that there is a proper amount of those of African American descent being represented in higher
Proper amount
education.
of African American representation in colleges.
I apologize, Your Honor. Could you repeat that?
Yeah, you referenced that this would no longer be needed once we reach the appropriate amount of African American students. What exactly is that amount?
Well, Your Honor, we see in UNC, who is currently using race-conscious admissions theory, even with them using this admissions theory, they still have a smaller amount of African American students than the state of North Carolina, where it is located. Their university is only made up of approximately 7.7% of African American students, which is not nearly as much as North Carolina's much more diverse demographic of 21% being African American in the state.
So if the university gets 21% of African American students, it'll job well done.
Your Honor, we believe that it certainly does show an improvement in the diversity of that campus, and that in turn will hopefully continue to grow and influence other campuses. And that itself, within its own school, has proven to at least elevate and grow the social structure of the campus.
Can you briefly explain how that would be different than the impermissible uses of quotas?
Yes, Your Honor. So quotas say that there have to be a certain number. There has to be, out of the student population, there has to be a certain number of African Americans or those of different ethnicities. We're not suggesting a quota. We're simply suggesting that the race be taken into account. By a quota, that excludes other races and other people eligible to get into the college. We're not proposing that at all. And what we are proposing is that this race just be taken into account a little bit more than it has been in the past, not as a deciding factor.
Your Honor, we find a quote in Fisher versus University of Texas, which directly addresses this idea of quotas. It says, as this court's cases have made clear, however, the compelling interest that justifies consideration of race in college admissions is not an interest in enrolling a certain number of minority students. Rather, a university may institute a race-conscious admissions program as a means of obtaining the educational benefits that flow from student body diversity.
Well, Counselor.
So, Counselor,
Sorry, Justice Hicks, go ahead.
so Counselor, if the compelling interest is to create diversity among the student body, how is affirmative action and only including race as a factor doing that?
Well, Your Honor, race itself has been, of course, we've seen the effects of racism in the past, and excluding certain minorities from activities, from land, from associate, whatever, by elevating affirmative action in universities and not really like taking anything else into account, as much as we are trying to bolster affirmative action, that will guarantee that the desire and that the goal of reaching a more diverse student body will be met.
But isn't the affirmative action in itself and the UNC policy creating Asian Americans to be underrepresented in schools? And so wouldn't that go against the compelling interest of creating diversity?
Your Honor, we've seen certainly in like the 1960s how we're not putting down the struggle of Asian Americans. They've certainly had their struggles in the past that cannot be overlooked. However, the hate and the struggle of the African Americans in, at least in the US, has, I can almost say, supersedes that of the Asian American struggle. I can't say that in every case, but I can say that
I mean,
probably in
so
general.
I have to push back on this for a few moments. Is UNC arguing this policy is needed to remedy past discrimination?
Your Honor, we're not saying that it's going to fix any wrongs done.
No. I'm not saying whether it's going to fix it, but is it intended to try to address past discrimination?
I believe that the main focus of this affirmative action is not to address that, but instead to just create a more diverse student body.
And why are you talking about all this past discrimination, and why is that relevant?
Well, Your Honor, African Americans especially, they have had those struggles again in the past, and we do want to see, and because of that, they haven't been given the same opportunity, especially in our.
Let me ask the question differently, and maybe if your partner, Aiden. Let's say we agree with you that African Americans are special. Other groups you're right, maybe have had less difficulties. Should they receive less affirmative action? Should we only allow racial preferences for Black students?
Your Honor, just as you had said, there are different levels to that amount of segregation. And we see in the report of the Joint Committee on the Reconstruction at the first session of the 39th Congress, it is said it was impossible to abandon the newly freed slaves without.
Again, I just answer the question. For groups who are not descendants from slaves, should they receive racial preferences to the same degree?
Your Honor, I would not say to the same degree. No, Your Honor.
Any degree?
I would
not on
say,
the mind. I mean, the 14th Amendment. Let's say we agreed they were trying to help the freed slaves. Why should other groups who are not freed slaves be able to benefit from this?
well, Your Honor, they just as you had mentioned, they have gone through an amount of discrimination.
But I said other groups, not Black people, other groups.
Right. So like those of Asian descent and
I think you said a moment ago that the Asians, didn't have it quite as bad.
Your Honor, yes. We believe that those of African American descent have had it worse than.
What about a first generation Nigerian immigrant? Would they get any benefits? A first generation Nigerian immigrant.
Yes, Your Honor. We do believe that he or she would need help in.
But his family had no contact with American slavery.
Oh, yes, Your Honor. Well, we still believe that racism, I'm pretty sure it's seen from everyone that racism still exists in America. We think back to the BLM protests where George Floyd was unfortunately murdered. Your Honor, we see that there is still racism and there still is that need to go on to that level playing field. The 14th Amendment.
So, Counselor, so are you stating that Asian Americans don't deal with racism either, and so that's why Black Americans should be treated differently?
No, Your Honor. No, certainly not. And I believe that's not the point that we're trying to make. Now, again, there is that hierarchy structure where I shouldn't say a hierarchy structure, but a classification of certain levels of discrimination. I believe that we believe that the African American community has suffered probably the worst within America. That's not, again, to dissuade the hate and discrimination that has gone on in the Asian American community. And this affirmative action, again, isn't going to be that deciding factor to say that this African American applicant is going to get more special treatment. It is just merely one piece in the puzzle.
But if I had two applicants, each with identical accolades in every way, but one is Black and one is Asian, the Black student's going to get in over the Asian student, would they not? So is it dispositive in that way?
So by that question, Your Honor, you mean to say they have like absolutely identical admissions paperwork or the same boxes checked? Yes. Okay. Well, Your Honor, to an extent, we do believe that, like you had said, they both have suffered discrimination, but we would give the leg up to those of African American descent, Your Honor, because of what they have gone through in America's history and all of the racism that they still do suffer today. And that's not to take away from those who do suffer discrimination that are of Asian descent, but we see it more prominent in those of African American descent. And it was a big issue, obviously, in America's history and has been.
All right, you may conclude, Counselor.
Your Honor, for the foregoing reasons, we pray that the court rule in favor of not overruling Brunner and in favor of the respondents to continue using affirmative action in UNC and throughout other college admissions. Thank you, Your Honors.
Okay, thank you so much. We now have 5 minutes for the petitioners to rebut.
Thank you, Your Honor. Thank you, Mr. Chief Justice, and may it please the court. We have 3 points in rebuttal. First, we think that when they talk about aiming for a specific number of underrepresented minorities, that is no different than quotas. And we think this is true because if you're aiming for, say, 20.35% of African Americans in the class and whatever percentage of Hispanics or other underrepresented minorities, we think that leaves you with a certain number that you can have for Asian Americans or whites. No matter how good Asian Americans are, they can't cross 80%. There is a racial quota in place.
But does UNC actually use that sort of quota, or are you just describing a hypothetical?
I think that that's sort of what they have described as their goal, right? We think that if your goal is to create this 20%, then you are not going to stop that.
When did they say their goal is 20%? I think they've tried to.
I think that I feel like that was what they said, and they do say it on page 5 of their brief. And we think that obviously that they're not tied to this goal, that if the court finds that they don't actually need to keep this goal in place, and that I'm not sure that UNC actually practices this goal as a function of their actual admissions practices. But we think that if this is the goal that they're giving in court, we would just like to say that if that is in fact their goal, then that is equivalent to.
Let's say it's not. Let's say that they don't agree with that. Let's say that their goal is not to a specific number. Okay, respond to that argument.
Yeah, sure. And so that brings us to our second point, that say we can just emphasize a point that Justice Hicks made, that once you sort of get past underrepresented minorities, then having more Asian Americans isn't necessarily bad.
And not to mention, we think that different people obviously come from different backgrounds. Let's take it, for example, I'm Romanian, and I feel that I can add so much more to classroom discussions as our friends from the other side describe those educational benefits of diversity. I feel like I have something to add there. That being said, through UNC's affirmative action program, I have no place to describe where I'm from and actually check a box.
In your application essay, there's a personal statement, is there? Why couldn't you talk about it there?
There are places to talk about it in the essay, but it's not weighted as highly as it is through the check boxes where they check African Americans or Asian.
What weight do they give to the check boxes? That's an issue of some debate. How much weight do they give to the check boxes on race?
I think that there is significant weight because we don't think that every African American or every Hispanic is writing about racial discrimination in their essays, and we think that's probably not a majority of them, the applicants. So then we think that if you look at the numbers and that you see that the decile, we have there's a chart with deciles in the appendix where when you look at Asian Americans in the top decile, they get treated very similarly to African Americans and Hispanic Americans in the 3rd and 4th decile. So we think it does give you a similar
Let's go back to just a question asked before, and let's assume that the socioeconomic status is tried and it doesn't work, and they use some sort of top 10% program that doesn't work. And let's say that the entire nation gets to a point where affirmative action is not used and the number of Black and brown students at schools just plummets nationwide. And what do we do with that? How do we handle that sort of situation?
Sure. I guess that again, if your goal is not to sort of model some sort of population outside of there, then diversity can come from many different forms, right? That diversity can come from.
Okay with everyone sort of looking right. They may have different ideas, but they're going to look the same.
I don't think that looking the same is necessarily a bad thing, right? Like if everyone in the class looked the same, but they had different past experiences, I'm not sure how that gives us less diversity in the classroom.
So if they're all white and Asian, that'd be okay?
Well, it wouldn't be the greatest. I don't think that would actually happen. But if it did in fact happen, I think there's still diversity.
Okay, proceed, Counselor.
Yeah, and I guess if we could just have a third point, the third point in rebuttal was just we think that when they talk about sort of these different sort of past cases, we think that a lot of these sort of draw the exact same distinction that when they talked about, I think in their opening, they talked about the Freedmen's Bureau Act again. And we think that we just would like to emphasize that a lot of that can again be taken into account through essays, that if you do use essays to talk about past racial discrimination, that can capture a lot of the things that we're looking for in terms of sort of being treated badly versus race for race sake. And so we think that if you're trying to capture that, using essays is a much better method. Thank you, and we yield the remainder of our time.
Okay, thank you so much. All right. The case is submitted. That was fun. I liked it. I think both teams had a very good rapport. It seemed like you were enjoying what you were. Oh, come back on camera, Avik, and thank you.
Sorry.
No, that's quite all right. I think you're both having fun. You seem to be enjoying yourselves. And what I liked is that when I gave you very hard questions, you didn't cave. You sort of stuck to your guns, which is hard. I think it's an important point. I asked both of you sides questions and you didn't always know the answer, and that's okay. It's important to simply be honest with Your Honor, I'm not familiar with that case. It will happen. I also think the handoffs were pretty smooth. You were able to work together well. I think your pacing was good, your cadence was good, you're understandable. I'm sorry we had some technical issues. If you couldn't hear us, that does happen, but welcome to the world of Zoom. Real courts doing oral arguments on Zoom. So it's a trick. Like, I'd actually recommend being seated right in front of the camera than to be standing 5 feet away. Because when you're standing 5 feet away, you can't always hear and see well, and your voices were just a tad garbled. So for future, I would just be seated at a table. Abby and Dan, I'll have some specific feedback in a few minutes, but maybe give Abby and Dan a chance to comment.
Yeah, I think that both of the teams did so well. You guys were all very conversational, and it felt very, very fun. The only main critique that I would have, and I think it was for both teams, was, and this is just coming from the moot court world, is when you're stating the law or you're stating even an opinion or a fact, you guys used we think, I think, we think, I think. It makes it to where you guys are telling us the law rather than just telling us what the law is. And so just by not saying we think or I think, you get rid of that and it makes yourself sound way more assertive, because I don't know when you're saying that whether this is an opinion of yours or this is really, what the law says. And so that would be my main critique. Just drop the we thinks or I thinks and just say what you're trying to say, and then it makes it more factual. But you guys did great. Yeah.
Yeah, great job from both teams. Good job with responsiveness. A little detail-oriented stuff. For the petitioner side, I think you kind of want to stay away from saying that the all white or Asian scenario is okay. If I got a question like that, I would bounce it to something like, look, Your Honor, we of course we don't want that scenario, but we have some simulations, or this state did this where this wasn't a problem. Just kind of deflect away from it. But when I know y'all weren't trying to say that, you were trying to emphasize the importance of diversity of opinions and stuff like that, which is also a great pivot, but maybe not agree with that one specifically, but great argument. And for the respondents, I would stay away from specific numbers, because I know y'all weren't trying to say that quota is permissible, but once you start using a certain finite range of numbers, that kind of sounds like a quota, especially to someone that doesn't know all the facts of the case. But great job being responsive with like some really hard questions and just standing your ground and giving a hard answer. So good job to both teams.
All right, so some feedback. So first off, so for Avik and Anthony, you got to dress up a little bit more. If not a tie, at least a coat. I mean, that does matter, and that's one of the characteristics we grade you on. So just something to keep in mind. I know it sounds petty, but at our law school there's a uniform. It's a dark suit with a red tie and a white shirt. It's right, Daniel, right, Abby? For the guys, it's what you have to wear.
Yeah.
They drilled that into on day number one. I think, Avik, you have a very interesting style, right? You are so candid, extremely candid. Like, well, there's this thing and I don't remember what it is, but this other thing I don't remember what it is. If you don't know, you can say that if you're asked a question, but I wouldn't be so eager to volunteer the things you don't know, because I would never have known if you didn't say you didn't know. You could have just said the answer partially, and I would have been fine with that. Just you're almost candid to a fault because you're just so transparent, which is to Daniel's point later. Probably not best to say, yeah, I'd be fine if it's all white, right? I know what you were saying. I think what the better answer is there'd be no constitutional problem with that. Don't say, yeah, that'd be fine. What's the big deal, right? It just, you have to, and maybe actually Abby's point as well. It's not so much what you guys think, but it's more what the Constitution requires. And so, for example, Anthony pivoted to his Romanian heritage, which is, I'm sure a very important part of your life. Try not to make it personal, right? You have a client you're representing. It's not about you, right? And I think actually the three of those comments are related. Avik, a couple of times, this just sounds really petty, but you keep adjusting your glasses, and you might need to get them tightened. This sounds very stupid, but they should be sitting like up here, not down here. I have the same problem. I got mine tightened last week. You have to keep adjusting it. It does get a little distracting. So that's just a small thing. Go to any eyeglass store in 5 minutes. They have to tighten around the bridge and tighten the ear things, and it just stays in place. Also, if you kind of look around like this, which is also it's a mark of a smart person, because when you are asked a question, your eyes go up, and actually your eyes go up and your head goes up also, right? So to sort of just keep locked on the camera, because when you're on Zoom, all you see is the camera. That's all you see, right? And so when you break eye contact, you really feel it. On the substance, I thought petitioners were solid. You had a good command. You led off with the Freedmen's Bureau Act, and you acknowledged was that other statute, the military one, that did have race, but I think you acknowledged that well. But I thought your substance was fine. Just the things we give you, just sort of polishing on the edges, kind of just to polish out the rough spots. For my friends from New Hampshire, I think you had good pacing, good cadence. When I asked you the opinion for Justice Harlan, it was hard because you didn't hear me, but then eventually realized you heard me, you know the answer. So I think you should be a little bit quicker to say, Your Honor, I'm not familiar with that case. You kind of just danced a little bit, but the question wasn't going away. So if you don't know something, say, Your Honor, I'm not familiar with that case. I think I saw you swiping. I think that's what you were doing. Maybe you were just not, but look, was that swiping?
It was, yes.
Yeah, I know the motion anyway. I see students under the table swiping all the time in class. So I know what that looks like. Oh, that sounded awful, actually. Sorry, high school students. Abby's laughing. I have a Title IX violation tomorrow. But you should have your facts committed. Even if you want some stuff on paper, paper's good. Not all courts even allow you to bring in devices. And if you have a device, you should be careful not to start swiping. It should be something that's just clear right in front of you. But I'd recommend, at least for, I don't know, Abby and Daniel, they tell you paper, only paper. Yeah.
In our moot court, we
Yeah.
can't have notes at all.
Oh, well, yeah, no notes at all. Right. But when you're prepping, do you have any tablet with you at the podium?
No, nothing.
Yeah, no iPad. I think also, just this is sort of a substantive point. A lot of your discussion was on past societal discrimination and things of that nature, right? But keep in mind that UNC's interest, and you said this, was the educational benefits that flow from diverse classes, right? And these positions are in tension. So a couple of times I kind of nailed you on that. It's like, well, why are we talking about George Floyd and Black Lives Matter if we're really discussing, the benefits flow from diversity? So it's not that you were wrong, but I think you need to sort of package that discussion of racial justice into educational benefits from diversity, right? They're related, but I just got the impression that you were sort of arguing them as almost standalone arguments. Daniel mentioned this a moment ago, I think Abby as well. Once you start giving numbers, you are getting in trouble. And I think the other side pointed that was 20%, whatever the number was, right? Once you actually give numbers, you are walking headlong into a quota, and you cannot do quotas. You're not allowed to do quotas. So something just to keep in mind. But I thought also your pacing was good. You handed off one to the other was good. You didn't get flustered when we gave you some very hard questions. You sort of stood your ground, which is good. But again, you're all high school students. I have to remind myself, I'm talking to a bunch of, what are you, sophomores, juniors? What year are you all?
Seniors.
Okay, you're seniors. What about New Hampshire?
Seniors go.
Okay, so we're all seniors, right? So you didn't even go to college yet, and you're arguing well beyond your years. This was very impressive. I thought you were all very strong. Are you interested in law school? Any of you? Some of you? Maybe?
Yeah, maybe.
Yeah. It's a really good path, and I think about no, I guess 5 or 6 years, if my math is right. I will see you in law school somewhere and I'll come say hi. Do you have questions for me or for Abby or for Daniel?
I think so, yeah.
I think we're all set.
Yeah.
I think we're all set, Your Honor. Thank you.
All right, great. Well, I'm very proud of you all. I'll have the scores posted probably by tomorrow or so you'll get the results back very soon. And I wish you all the best of luck. If you have any questions about law school, you can always email me. I'm always happy to talk to students. And if you're ever in Houston, come visit.
Thank you so much.
Thank you, Your Honor.
So the assistant, please sign off. I'll talk to the judges for a few minutes and I will put the scores in. Bye. Bye. All right, let me turn the recording off.